I'd like to speak in the first reading of the Insolvency Practitioners Bill, and as you've heard, the Labour Party does support this bill. I'd like to thank the Minister Simon Power for carrying out the work of the Fifth Labour Government in strengthening the rights of creditors, and support his assertion that insolvent companies must be handled with integrity. And also I'd like to commend tonight the work done by my colleague, the Honourable Leanne Dalzell, for her involvement in this issue. This bill brings insolvency practitioners up to standard by introducing a negative licensing system which gives the Registrar of Companies the statutory authority to place under supervision or prohibit individuals from providing corporate insolvency services for up to 5 years. And insolvency practitioners carry out liquidations, voluntary administrations and receiverships. And a minority of those practitioners who are underperforming lack the necessary skills and competence in repeatedly favouring debtors at the expense of creditors. I think we heard tonight that there's around 100 practitioners in New Zealand, and a mandatory licensing system would not be cost effective, and this bill aims to make it easier for practitioners who are unfit to practice to be prohibited or placed under supervision, rather than forcing a creditor or another party from having to go through the rigmarole of applying to the High Court to get a practitioner prohibited from practising. And this bill will also give protection against self-interested practitioners who in some cases have put their own interests or the interests of the insolvent companies who may be owed money. And the Labour Party supports any measure which strengthens and upholds corporate integrity in New Zealand, which is why the last Labour government recommended in August 2008 that a negative licensing system be adopted for insolvency practitioners, and we're glad to see that the current minister is carrying on that work. Labour's concern is that in any case where a company is made insolvent, that the creditors that are left, that it's the creditors that are left wanting, and it's the protection of those creditors which is important. So the purpose of insolvency law is largely to protect against resource-intensive court proceedings where creditors are forced to compete to recover their debt. So we need to ensure that financial failure is dealt with certainty and clarity, and a clear set of rules for who gets what and in what order. And we believe that this bill goes some way to addressing this. As I previously mentioned, and I know that has been mentioned by my colleague Leanne Dalzell, there are fewer than 100 or around 100 insolvency practitioners in New Zealand, and a lot of trust is put into these few who are charged in carrying out liquidations, voluntary administrations and receiverships. And those processes require a practitioner to carry out the skilled tasks with sound judgment and integrity, and mostly it's important to note that expectation is upheld. But there are always exceptions, and it's the underperformers that this bill targets. And the current law, as it stands, provides minimal restrictions as to who can be appointed as a liquidator, administrator or receiver, which means that practitioners with very little knowledge of commercial law and of procedures set out in relevant legislation can be appointed to manage or wind up an insolvency company, which can lead to failure to discharge their statutory obligations to creditors, among other things. And what this bill does is establish a system which targets practitioners who fail to comply with their duties and places them under supervision, and or prohibits them from acting as a practitioner for up to 5 years. And that negative licensing system is being adopted as a more cost-effective option rather than making it compulsory for all insolvency practitioners to be registered, a system which, if implemented, would cost several $1,000s a year and deplete the funds available to creditors. So this bill would give the Registrar of Companies the power to take into account failures that have occurred up to 5 years before now, and practitioners are able to appeal to the High Court against a decision of the Registrar. And this bill amends the Receivership Act 1993 so that the High Court may make a prohibition order in relation to a receiver for an indefinite period. The registrar is able to fine those practitioners who don't adhere to their terms and conditions up to $10,000 under the Companies Act of 1993. And this bill also requires the registrar to maintain a public register of people who are subject to prohibition or supervision, which is information about practitioners which is easily accessible to the public. And last week in the New Zealand Herald, there was the story of Ram Rai, a former restaurant owner who got into a dispute with liquidator Gilbert Chapman over the amount they were charging him, and through action in the High Court, Mr Rai was successful in reducing the charges from Gilbert Chapman from around $63,000 to $25,000. And in his summary, the judge, Roger Bell, noted the difficulty of the process of challenging liquidators' charges, saying that most times it is not worthwhile for a creditor to do so, and that to a certain extent leaves the liquidator in a position of some immunity. So this bill would go some way to resolving this problem by allowing the registrar of companies to suspend incompetent or delinquent practitioners based on their prior actions or current performance from operating in the insolvency industry. And these reforms will enhance transparency and accountability, which is an important thing in the insolvency profession, by ensuring that only skilled and competent practitioners are appointed and that returns to creditors are maximised. So it's important to note that the current lack of regulation means that although the profession plays a crucial role, there's no official record of the number of practitioners or their qualifications, and we need to make the financial sector more open and transparent, which is what my colleague, the Honourable Leanne Dalzell, strived to do as Commerce Minister in the last Labour government, and it's good to see the current Minister putting partisan politics aside and following in her footsteps. And Labour wholeheartedly supports a licensing system that lets creditors know that insolvency practitioners are competent in their specialised areas of work and are capable of maximising returns from financially distressed businesses, which is why we're supporting this bill.
Call David Clendon.